Okay. Hi, good afternoon. Welcome. This is Think Beyond the Keys, and I'm your host, Melvina Fredson-Cole, and I am excited. I am going to speak really fast through this introduction because we are up here in Northern California, and our guest speaker today may have to evacuate. So I am excited this week because this is something that is emotional to me, and it's all about estate planning and probate, wills, and conservatorship if we have time. But I have with me an amazing lady. She is an attorney. Her name is Kendra Bowens, and she focuses her mostly on estate planning but in particular what drew her to me. But if you look at her bio, I have her link in the description, but if you look at her bio, her legal work is specifically to prevent probate, and when we discuss it you'll understand why. And she is a San Mateo County native. And Kendra receives great satisfaction in using the law to help other San Francisco Bay Area residents and homeowners avoid the time-consuming, costly, and disruptive probate process. Kendra meets with every client at Fidelity office, law office near them. Don't worry if you're not near San Francisco, her information is relevant where you are. And she guides them through the estate planning process in a fun and efficient way. Her positive approach and knowledge of estate planning law ensures that each client makes the right decisions for their estate and family. Having completed thousands of estate plans, wow, thousands, so you know she knows what she's talking about. Kendra has successfully worked through nearly every possible family and estate situation. So if you're going through a situation, it is possible definitely that Kendra has worked through that. And including her own journey with now two deceased parents. Most clients comment that their estate planning process with Kendra is much less of a chore than anticipated and are very happy that they elected to work with her. She currently resides in San Mateo County with her family. And I have to add to that Kendra also, she volunteers and works and spends time also with the Housing and Economic Rights Advocate, where she also does educational workshops for the public and training for attorneys at the Housing and Economic Rights Advocate. So welcome, Kendra. I'm so excited that you're here with me.
Thank you so much, Melvina. Yes, a wonderful introduction. I sure appreciate that. And I'm happy to be with all of you and happy to virtually meet all of you. And we will have a nice hour or so here, hopefully discussing a lot of issues that some of you may or may not be thinking about. If you're not thinking about them, perhaps it's time to do so. While we do have a little more downtime these days, because estate planning, you will see, is something that everyone needs. Really doesn't matter what you own or how you own it, everyone needs some sort of estate planning.
Okay, so let me just clarify this for our audience. What is estate planning?
Yes, so I see estate planning as two groups of issues and two types of documents that attorneys need to prepare. So what most of us typically think is estate planning is what happens to our estate, our stuff, our home, savings, whatever we happen to have at death. In order to transfer title at death, we either need a will or a trust. A trust is very important if you own a home. You will find, as Melvina and I talk, that if you own any asset worth over $150,000, your family will have to go to the probate process unless that asset is either in a trust, in a transfer on death deed, or has beneficiaries on them. So there are several ways to avoid probate, but you have to take active steps now while you're feeling good and with it and going through all of the proper formalities to make sure that once again, you either have beneficiaries on an asset or typically put assets into a trust. That avoids the public, expensive probate process that we have here in California, unfortunately. So one group of estate planning documents and one group of issues that we deal with are what happens when we pass away. What's the distribution of assets, and for those of you who still have children under the age of 18, who would be the guardians of the children. But the part of estate planning that sometimes people don't think about are what happens if we were either permanently or temporarily incapacitated. Who would pay our bills? If our property taxes were going up unfairly, who would argue with the county assessor's office to have a fair conclusion drawn as to the appropriate amount of property tax? If we're in the process of filing our income taxes and then we became incapacitated, who could properly and legally sign for an extension so that when we hopefully improved, that our life would be as it should be instead of a complete mess?
Yeah.
So the second group of estate planning documents involves what happens to our finances and what documents are in place to handle those finances if we were either permanently or temporarily incapacitated. And then on the flip side, again, if we were permanently or temporarily incapacitated, who is going to advocate for us in a medical setting? If you prepare an estate planning document called an Advanced Healthcare Directive and HIPAA, you will have nominated someone to advocate for you to implement things in the way that you wish with your medical providers so that your intentions will take place rather than someone imposing what they want for you, or without a hospital just all of a sudden doing things to you that you might not want if things were quite dire. So once again, that group of estate planning documents concerns issues that come up while we're alive. Who's going to handle our health care and advocate for us? What do we want to have happen if we ever have Alzheimer's, dementia? With those issues, and an advanced healthcare directive is the appropriate document to have prepared, as well as a HIPAA. And then once again, if we're alive but incapacitated and we want to nominate someone to handle our finances, we need to have a power of attorney prepared. Power of attorney nominates someone to handle finances for us, file taxes, etc. For all of those choices, I keep saying nominating someone. I like a first choice typically, and then a second choice in case the first choice herself or himself is also down.
Okay.
So that group of estate planning documents, and then the documents that take care of the issue of what happens to our assets or our children at the time of death.
Wow. You know, that's one aspect that people don't think about whilst they're alive. But I'm going to come to that because that's a whole issue that we need to talk about. I want to talk about our assets right now.
Okay.
I want to chat about that because I've been having conversations and people are saying, oh yeah, I've got a will, I'm fine. So my question to you, is that fine? Because a lot of people now, you know, they have assets over 150,000. They've worked all their years. They have homes. They have different things, and they have kids. And they said, "Oh, we have a will, and that's fine." So, can you talk a little bit more about that? Is a will just okay?
Yes. So for some folks that come in, a will is okay because if you own assets, gross value of those assets that do not have beneficiary designations on them, if the leftover stuff is under $150,000, there is not a probate of a will. Probate kicks in when you own gross assets without beneficiary designations that total over $150,000. So if you own any kind of a home in California, you own an asset most likely over $150,000. And keep in mind, the probate court does not care about the size of the mortgage or loan against the house. They just care about gross value. So for folks that maybe are renters and have a retirement, a little bit of life insurance, have beneficiary designations there, they can get by with just doing a will because it's not much of a probate at all that they're next in line would have to go through to get that designation handled by a probate court. But for other folks who own assets over $150,000, and that is the threshold that we have here, if you just have a will is subject to probate. It's kind of like, it's the same process as you would go through even if you didn't have a will. So if you don't have a will, your family goes through an administration, which is like a probate. And if you have a will, but the gross value of your assets without beneficiary designations is over $150,000, there will once again be a probate. And probate is a public process. So your will be public. So everyone will know where your stuff is going to go. You may or may not like that. You will typically have to hire an attorney like me. You will have to jump through all kinds of legal and publication formalities. It's expensive. Probate fees can take a chunk out of an estate. It's statutory, so lawyers are going to charge the max that they can typically. And it's sad when that happens because it was very easily avoidable if that individual or if that couple had prepared a trust rather than a will. So that's the difference. Both distribute property at death, but if you have gross assets over $150,000 where you can't place beneficiary designations, that's an instance when you would need a trust.
Okay.
Keep in mind also that a trust is you. You are your trust. You are the trustee of your trust. You own the assets. No one can change the trust other than you. You can sell it, spend it, move to Tahiti. You have complete control of those assets. You're accountable to no one. When you create a trust and you convey your real property, your home, to your trust, there's not even a reassessment by the county because the county views that type of revocable trust as you. So I do have folks that are worried about the fact that they feel like they're giving up control if they put their assets into a trust, and that is not the case. The main purpose of a trust is distributing property at death without probate for people who own over $150,000.
Yeah, so probate is a court proceedings that if you have a will, and even if you leave a will, what happens is that you already may or may not have assigned someone to take care of what's in the will, what you've written, right? And normally that person, I think it's called a PR, a personal representative. That
yes, or an executor, yes.
Yeah, or an executor. And then so what happens is like now, unfortunately, when it's a will, they have to take it and file it in court. Am I right?
Correct. Yes, it is public.
They have to take it and file it in court. And I can tell you, because I'm a certified probate real estate specialist, I've been to the courts and everything they say on the will is public. I can read it, like who they left what for and everything like that. It's public knowledge, but you have to file it, and then it takes time because it's you file it in the county, right, where the property is. Now, I want to ask you a quick question about that. If this deceased has got a will, but they have property in different counties or maybe in different states, and they only elect one executor for that estate, for all the estates, how does that work?
They would look at the aggregate of what they own. And so if you own a property in Alameda County and then a rental property in LA, they're going to look at the aggregate.
Okay, so they only have to file one. What makes a distinction on where they file? If they have one in Alameda County, one in LA, one in Florida, and one in Texas, and then so how do they still take the aggregate of it, and where do they file it?
So in California, it would be where the decedent last resided, where their domicile was. In property in other states, there would be a probate in each of those states.
Wow.
Yes.
So they have to file in each of those states.
Yes. Now in Florida, it's a little bit simpler, and in Texas than California, but still you're going to have to go there or perhaps hire someone there to handle that. Ideally, if someone owned all those properties, the decedent, the individual would have created a trust, had each property placed in the trust, and then the successor trustee would just handle it and do whatever those documents state on them. So you can create a trust here, convey your California property to this trust, convey your out-of-state property to this trust too, and then it's really one-stop shopping. So once again, you're saving a bundle of money in that respect too.
Okay, so that's great. So you can just open one trust. It's like opening an account and depositing different things in it, irrespective of where they are in the state. And that leads me to something else, because people speak about trusts are expensive. Because I ask people, it's like, why didn't you just create a trust? It's like, oh no, it's too expensive and there's ongoing fees. So is that the case? Why is there ongoing fees?
Yes. So some attorneys actually do charge an ongoing fee for creating a trust. There are plenty of attorneys who do not charge a fee, $300 or so. There's no reason to do that because, like I said earlier, you own your property, you are your trust. if a trust is set up, let's say to take care of someone who is disabled, let's say they're receiving SSDI and they cannot have assets in their name and continue to receive benefits. So then a special needs trust is set up, and the trustee of that trust, the individual handling the money or the bank, would be entitled to a fee once that trust is kind of kicked into gear. So when someone dies, they can say 50% will go to my son who is disabled, and I never want this property in his name, but I want the money to be used for his health, education, et cetera, living expenses. So then the trustee will charge a fee at that point. But when you're alive and you create a trust and you put things into the trust, at that point, there's no fee. When you die, the successor trustee can charge a fee. The most common fee in a trust is about 1%. Sometimes you can say 0. It really depends on what works for you in your particular situation. But the probate fees, the executor fees, and the attorney's fees to handle a probate will be much more than 1% of what you.
Oh, definitely. I think I read that normally the fees are between, like, it can go like 4% up to 7-8% depending on the estate.
It can, yes.
Yeah, gonna take a chunk out of that.
So it will. And sometimes then if there are no liquid assets, then they have to sell something in order to pay that fee.
Yeah, and another thing also with the probate, if the person is still paying mortgage on the property or other properties, whilst in the process, which can take anywhere between 4 months or up to over a year, depending on a lot of things that may happen, a year or two, right, Kendra?
Oh, easily.
You have to be paying the mortgage.
Exactly.
Or else you can go into foreclosure. They don't care. I mean, the lenders, like, they have to have their monthly mortgage. So that's another challenge with with the probate when you have it, and the PR or the executor have to make sure that they maintain the assets. Am I right? They have to have an inventory and make sure they do their due diligence to make sure that they safeguard the asset until it's distributed. Am I right?
Exactly. Yes. They have to do what's reasonable under the circumstance. Sometimes they have to take out a loan on behalf of the estate. They are beholden to all of the beneficiaries to really do everything they can to get the most amount of money. But sometimes they have to have a rather desperate sale at some point when there's no liquid cash in order to meet some obligations or a big tax bill that might have been added up over several years. So yeah, it's very easy to avoid by creating a trust instead, because a trust is a private family document. It is not filed. Typically when we create a trust, we have the clients transfer one of their accounts, their bank account, into the trust. Then if people die, the trustee can easily access that money. They basically present an original death certificate. And at that point, they can access the money and just keep paying bills out of that trust account. So there's not the confusion and chaos that can be brought on by a probate.
I know, that is so simple. You just like carry on, and then they don't have to wait for a court order, because depending on the type of probate and how it's filed, you may have to wait for the court to approve the sale of the property to pay debts or whatever that needs to be done. And also the court has to approve the amount that you're selling the property. I mean, it's a lot. It's like you lose control of everything.
You do, because you keep waiting for court approval, and everything is 30 days and 30 days. And in court, often the time that you give people to respond is 30 days. So time can be of the essence. And once again, with the trust, the trustee is accountable to all of those beneficiaries. But again, presenting death certificates to the bank, or if they were going to sell a house, let's say it was a declining market and they wanted to make the most of it, well, they could decide to sell the house rather quickly, and they can sign on behalf of the trust because they are the next in line for that trust. They don't have to prove anything to the court. So it's just really 2 death certificates or 1 death certificate in the case of a single individual. So there's a very big difference. But sometimes people might be talking about the money that needs to be spent up front to create a trust, an individual trust for a single person or a marital trust for a married couple. And so that, it can be several $1,000s. So sometimes that can be a factor, but spending a little now and doing some planning now and thinking about these decisions now. And I understand that these are not fun things to think about. It's very easy to postpone thinking about all of this, but doing so now will save a lot of headache, heartache, and money later.
Absolutely. And there's some lawyers that charge an upfront fee and then nothing else. There's some that charge ongoing fees. And my question to you is, what is the filing fee, or is it necessary? Can it be avoided?
Well, there's no filing fee for a trust because it's a private family document. So you're going to hang on to the originals. Your lawyer will, of course, have a copy, and you'll let your next in line, your successor trustee, know where you're keeping the originals. They don't have to have a copy of it, though. So where you're keeping the originals, and it's always a good idea to let them know your lawyer's contact information in case the originals are inadvertently destroyed. Your successor trustee could get a copy of it at your death. Cannot do so prior to your death because that would be unethical, but at your death, the lawyer could provide a copy to your successor trustee. So the only filing fee is, once we create a trust, we're going to have you sign your new deed conveying your interest as trustee to your trust, the Jones Family Trust. And so that deed is filed, and it's typically about $50 to file that deed. And that's really it. Your property taxes will not be reassessed because this is the type of trust that 99.5% of us need in order to just avoid probate. So filing that deed is inexpensive, and it will end up saving your family a lot of money down the road. Let's say you sell your home though, and then you purchase a new home. It's not a big deal at all. You will sell your home just as you typically do, sign all the loan documents, but you will do so as trustee or trustees of your trust. And then you will always purchase new property in the name of a trust that you've already created. You don't have to even change your trust. The distribution language in the trust, let's say you have 3 kids, at death, everything's going equally to 3 kids. It will apply to any assets in the name of the trust. So you don't have to keep changing your trust or feel like you have to wait until you have everything you're ever going to have and then create your trust. It's meant to grow with a family. And you're just going to put new things into it as you go through life. You sell a home, you put the new home into it. You open up a new bank account or investment account, you will do so in the name of your trust. At the outset, when you first create a trust, there's a little bit of legwork on your part where you do have to change some of your accounts to the trust. And speaking of that, the accounts you would not change into the trust would be your retirement accounts, because there can be adverse tax implications there. So you will stick to your beneficiary designations on your retirement accounts and oftentimes life insurance, but you can always put the trust down as the last contingent beneficiary. If you want, let's say you have no children, you want your spouse to be the first beneficiary of your retirement account, and then you have nieces and nephews, and that's what's stated in your trust, you can just put the trust down as the second beneficiary of that account in case you and your spouse were to pass together.
Oh, there's a lot. And I know that each situation is different when it comes to trust. What I want to ask about trust, I've heard that sometimes something happens and some people take things out of the trust and forget to put it back. And so what they take out, if they pass, that part, if it's more than 150,000, goes through probate, whilst the others is okay in the trust. So what is that all about? What is taking it out and putting it in?
Right. Very good question, Melvina. So it usually happens when people refinance, and the title company isn't doing it to hurt their clients, but they might not know how to work with trust. And even if they take it out and have you sign all the documents personally, at the end, they're supposed to have you deed your property back to your trust to put it back in the trust. Sometimes they don't. And so if you have a trust and if you have recently refinanced, get a copy of your grant deed from the county recorder's office and make sure that it was put back into your trust. It should be a 1 to 2 page document. If that has not taken place, as long as you're with it and have capacity, now is the time to fix it. You can very easily have it popped right back into your trust, and there are no ill effects from that. If you can't, obtaining grant deeds is a little harder nowadays because a lot of county recorder's offices are not open. But I know that Santa Clara allows people to go online and obtain those. I believe that LA County does as well. You can always look at your property tax statement though too, because sometimes it will have your name and then TEE or TRE, and that means your name as trustee. And that's usually a pretty good sign that it was placed back into your trust.
Oh, okay, awesome. So when the person gets the deed, do they have to go to their lawyer? That's something they can do on them by themselves, or does a lawyer have to do that?
A lawyer does not have to prepare a deed conveying property back to a trust. They could do it as long as they do so correctly and as long as it's notarized and filed at the county recorder's office.
Gotcha.
There's also an accompanying document called a preliminary change of ownership report, which they would complete. It's very simple, and they would file that along with their new deed.
Okay.
And
So,
there are some little boxes that they would check, and they would check yes to the box that says, I am putting this into my revocable trust. And that tells the county that there should be no reassessment with respect to that piece of real property.
awesome. Now, when we speak about estate planning, we speak about trust, and it's normally we think about old people. So, but I was thinking, I'm like, well, there are some people, they're young, but they're married, they purchase, they have property, they have assets, and they have kids. So how, is there an age limit to start your estate planning? Is it for only older people, or what's the age?
Good question again. So over the age of 18, people have the ability to create estate planning documents. So I have one financial planner who has sent a couple people my way. When they go to college, they get their power of attorney and their healthcare directive done. So if they get into a bike accident or a skiing accident, they have someone on tap to do things for them. Doesn't happen very often. So I will say for most people, individual or married, when they start to accumulate assets totaling over that $150,000 mark, if they buy a condo, if they go in with a partner, a half interest in a condo, because they probably at that point own an asset over $150,000. So that is a good time to do a trust. And then of course, when a couple has kids, you want to make it very clear who the guardians would be if something happened to the parents. So that is another time that I get young couples coming in, and that should prompt people into having estate planning documents created when they have children.
So if they have children and they want to create something to say, and they haven't had the estate yet, they haven't purchased a home, but they're like, I just want something legal because if anything should happen to me, I want this person to take care of my kids. What is that document called? What is that? How does
So that would be a will, because it would convey property at death, but they're under $150,000, right? But it would also legally designate a guardian for that child. So if the person or if the couple did pass away, there would be a very strong presumption by the court that these parents thought about this, that this person is probably the best in line to take care of the child, and a judge would typically just sign off on that. If there is no indication, there are court hearings, and all of the family has to be alerted as to the death of these people, and all of the family can hire lawyers and argue about who would be best to take care of these kids. All of them may be well intended, but it can just lead to delay, and it might not be what you would want in the end.
Okay.
Yeah, so a will could work for those types of people. But if they do anticipate purchasing a home, let's say in the next 5 years, they could just go ahead, create the trust structure, name guardianship choices in the trust. And then when they purchase the home, they won't have to, at that point, create a trust. They can just give an abbreviated version of the trust to the title company, and the title company will automatically place the new asset into the trust. So that would be okay too, if they anticipate owning assets over $150,000.
Wow, that's great. That's great. I'm going to go back to the Advanced Healthcare Directive, because that is something that people don't talk about, and it's really important. And I was really amazed that there's some people over 18 already have that, and some people, some of us don't have it. Which
it happens scary all the time.
Yes, which is scary. So now, let me just say, I want to have an advanced directive. Is that what you call it? Advanced Healthcare Directive. And I noticed that there's two different types. You have one for you can have one for that is the advanced healthcare. Then you can have one for to handle the finances, right? You can have two separate people.
Exactly. And there might be two different choices on those documents. All of us have friends who are maybe very good with details and finances, but with medical issues, you know, get queasy at the sight of blood. So that would not be the best choice for a healthcare directive, and vice versa. Some people, if you have a friend who is a nurse or a doctor, that's a great choice for a healthcare directive, but that might not be the person that you want to handle your finances if you were down. So that can be quite common.
Okay, cool.
With each of those documents, with the power of attorney, you have two choices. It can either be springing, which means that one or two doctors need to state in writing that you are unable to take care of your financial affairs, and that would allow the next person up to start to legally do things for you. Or you could just get the basic one where you have complete trust in that person, and even if you were out of the country and stuck, couldn't fly back due to COVID, that person in the power of attorney could do financial things on your behalf and for you. They're your fiduciary. With the healthcare directive, the doctor is always going to try to communicate with you as long as they feel that you're with it and you can do so yourself. They will always defer to that. But at the point in time when they cannot do so, that's when your agent is on deck to start to make good decisions for you and implement things that you will have thought about in your healthcare directive. So my healthcare directive really forces people to think about some rather gruesome things. I mean, if you are in a coma and two doctors say it's irreversible and everything is dire and you're not going to come back to having any quality of life, how many days do you want to remain in that coma? How far is your family? Do we give them 3 more days, 30 days, 10 days? It's really whatever you're comfortable with given your family situation. It will have people think about a situation like if they have irreversible dementia or Alzheimer's, if they are receiving no medical treatment, do they want to be force fed or fed through an IV, or do they want to just refuse food and water by not opening their mouths? So you really have control. It takes a lot of the weight off of your next line of people if you are quite specific about what you want and what you don't want. And you'll change that as you go through life. My young couples tend to want more, more days in a coma. My older people, sometimes they're fine with the minimal. Yep, it's just, I don't want a lot of things done. Let me go home and let nature take its course. So you can change these documents as you go through life and as the situation changes.
So does a advanced healthcare directive, is it necessary for spouses because, they're married? Is it necessary, or does that, because if you go to the hospital, automatically they look at the spouse. So if it's just, that is not necessary, right? To do.
Yeah, with spouses, it's more automatic. Once in a while, I have an older couple where both of them are rather fragile and they don't want that next person to really have to be the one that doctors communicate with, and they want, their most responsible child to have that role. And so it doesn't always have to be that way. But I think it's also good to indicate your specific choices about what you want if you're ever in a coma, if you ever have Alzheimer's, if some things happen to you, it gives some guidance, because you have to think, let's say you are with your spouse, but both of you are in an accident, or one of you passes and the other person is in intensive care. You need someone on deck, a second choice. So it's always important to think, okay, if that person isn't around or is unable to help, who would my second choice be?
Yeah, that is important to do, because then there's always a lot of confusion and,
and time is of the essence.
Yeah, time is of the essence. And I noticed that you said that you practice solely on estate planning and advanced estate planning. What's the difference?
So advanced estate planning would be like creating special needs trusts for disabled children. It would also be, and it's not as important today, but creating trusts where people want to give their assets away, like while they're alive, to gain certain tax advantages. So give it to charity now, but they have 5 homes, put 1 home in an irrevocable trust, but they can still live off of the income from that rental home, but it removes it from their taxable estate. So it usually has to do with avoiding some estate taxes. Right now, the estate tax limit is so high that for an individual, there would be no estate tax implications unless you owned assets over $11 million. For a married couple, that's doubled, so it'd be $22 million. In 2026, that will be essentially cut in half. So for an individual, if you own assets under 5.5 million, it shouldn't be an issue. Or for a married couple, you can own assets over 11 million. So it's not, it doesn't come up very much.
And that's for California?
Yes. Oh, well, no, that is federal.
That's federal.
Yes, because our probate fees are California, our state, but those are the federal exemptions. Yes. Yeah.
Wow.
So just something for people to look at if they are kind of close to that threshold. Let's see what happens in 2026, but everything's supposed to revert back to the way it was of 5.5 million a piece. If someone owns a nice home and some other stuff, they could be rather close to that.
Oh yeah, especially here in California. I mean,
absolutely,
like,
yes.
Yeah, you can get to that threshold really quick.
Yes.
I just before you leave, I know, like, time is of the essence. I haven't heard anything, right? You haven't heard anything.
Yes, so far so good.
Okay, real quick. You mentioned special needs, and I just want to because I'm sure there might be parents here listening to this. So what is it? How do they set it up for their kids, and what are the advantages? Yeah.
So let's say with the family, you have 3 kids and they're mostly financially responsible. The kids will get assets if you receive assets if you pass away at the age of 18, unless you put limitations in there. So most wills and trusts say money could be used for health, education, maintenance, and support at any age I pass, but at age 25, that is when the checkbook is going to be handed over. So that's when the kids would gain control. And it could be whatever age you would like. You know your kids the best. It could be different ages for different children. Some people have children who have conditions where they'll never really be financially able to take care of their finances, or they have a disability which causes them to receive some kind of disability like SSDI. So one of the requirements for receiving some types of benefits is that you cannot have assets over, let's say, $2,000 of your own. So those parents do not want a 1/3 share of that estate to be given to that child in some cases, because they want to make sure that this child is receiving various services and maybe some medical insurance that is also subsidized. If that is the case, 2 kids could receive their portion outright at age 25, but this other 3rd child who may be more challenged, it really wouldn't be able to financially take care of their assets. That 1/3 can be placed in a special needs trust. That child will never have control of those assets, will never have it in their account under their name, but there's trustee, it could be their sibling. The trustee of that special needs trust will control the distribution of the assets. So if we've set in a trust that it can be used for that child's health and education, or that it can be used for other supplemental things like trade skills, and the child loves, doing something that helps that child mentally, psychological work, something like that. The money can be used for those purposes, but doled out by the trustee as shown as needed by that individual. So that person will never own those assets, but the money should be used for that child in a way that fits that family dynamic.
Okay. Well, thank you for your time. I know there's a lot more. I mean, because this is just it's not even scraping the surface when it comes to estate planning, and there's so many issues that are involved in it. And before we leave, because I really want people to understand that, if you can avoid probate, avoid it if you can. And so do you have any stories at the top of your head that you had to, go through that shows that how a probate can, it's not a good thing to go through?
Yes, well, having nothing is awful, because then families are going to fight, and dad said he wanted this and he might have told another child something else. It can cause a rift for the rest of the lives of kids unless people are clear in their documents about where they want stuff to go. So that's always very, very sad. In situations like that, sometimes the heirs will lawyer up. So everyone's spending a lot of money on lawyers. And in the end, not that much is left to split, but people have dug their heels in. So all of those situations are sad, a big waste of money. So by putting maybe 3 to 4 hours of time now, thinking about it, filling out a workbook with an attorney, looking at drafts with that attorney, reviewing it and tweaking it and making sure that it's absolutely reflecting what you want to have happen, and then signing it, about 3 to 4 hours of work can completely avoid all of that chaos and misery, and really just putting a really bad taste in the mouths of your heirs down the road. Gee, it would have been great if dad had handled this and not left us with this awful situation, when you've probably done some really nice things for your kids, but that's what they're going to remember. So a little bit of time, a little bit of money now to avoid that is time well spent, I think.
Thank you so much, Attorney Kendra. I appreciate your time.
You're welcome. It's been a
maybe
pleasure.
Maybe you may come back again, because there's so much that needs to be
I'd be happy to. This has been a lot of fun.
Yes, it has. And I hope that the fire doesn't get to you.
Yes, well, we have a plan, so we're gonna.
How about the smoke? Is it really a lot right now?
We live relatively close to the coast, so we're not very smoky. So that's why it's almost hard to understand why we need to evacuate. But it's, it's about, I guess, 10 to 15 miles away, about 10 miles away. So, but it is heading south, and we live a little bit north of the fire. So it's bad for whoever it's heading towards.
Well, thank you so much. And this is Melvina and Attorney Kendra with Think Beyond the Keys. I have her information right there in the description. And I would let her, she will come back maybe in another month or two, and we will talk a little bit more, and also talk about housing and economic advocate. There's so much to talk about. And but right now, everyone out there, be safe. Make sure you listen, and if you have to evacuate, evacuate. Your life is worth so much more than that. And if you have assets over the $150,000 threshold, and you have kids, it is really important. If you live here in the Bay Area, just like call Kendra and just like ask her, have a session with her. If you already have unfortunately, if you're an executor and you can contact me. I know a lot of different people, and we can help you out. So this is just to help you out and make sure that everything is in order. And we've worked hard for these things. Over the years, you put together this thing, and now there's a large transfer of wealth happening. Just make sure that when that wealth is transferring to the next generation, a chunk of it isn't cut out through everything and, publicized to everyone. Just make sure that it is kept within the family. So have a great week. Kendra, keep safe. And I'll see you next week on Think Beyond the Keys. Those of you homeowners, stay tuned, because I have something special for you if you're thinking of selling your home. Take care. Bye.
Goodbye, everyone.